You ever had these comments in your head? I don't want to talk about death. What do I care what happens to my assets when I die? I'm dead. Let my kids figure this out. These are common thoughts that people have when they're asked, do you have a will in place or do you have any estate planning documents? My name is Alina Núñez and I am an attorney who handles estate planning, and I'm here to talk to you today about the misconception of what happens to your assets when you die without a will. There is often a misconception that if you die without a will, the state gets to keep all your assets, and this is not true. Now, there are certain assets that you might have that will go directly to your heirs. If you have a bank account with a beneficiary named on it, or a life insurance policy, or 401k, most of these you have selected and named who you want to receive those assets when you pass. Anything else that you don't have a beneficiary named on becomes part of your estate. And that is what has to go through a court process to find out who's going to receive what. Typically, a will is the document that you leave signed saying who do you want to receive these assets. But what happens if you die without a will? This is how the court will determine who receives what. So what happens if you do pass away and you don't have a will? The way that the court determines who receives your assets is through what we call intestacy. Think of it like a family tree. It's your children, or your spouse, or your parents, or your brother. Depending on the situation of whether you're single, you're married, if you have children or you don't, the court will try to figure out who of these people is the one that's going to receive your assets. Now, if you pass away without a will and you're married, there's a very good chance that your spouse will inherit your assets. But that depends. Do you have children from a prior relationship? If you do, this is where things can get a little bit tricky. And this is why it's very important that you do have a will, laying out exactly who you want to receive your assets. Please don't think that just because you're not a millionaire, that it's not important for you to have a will. What it does is it allows you to make the decisions of who's going to receive your assets and not place it into the hands of the court. What happens if you are in a domestic partnership with someone, or you've been living with someone for 30 years, but you're not legally married? Well, unfortunately, the state of Florida does not recognize domestic partnerships. And although it's your intention to leave your assets to that person that's been by your side all those years, they will have no legal rights to inherit under the law. Again, another reason why it's very important to make sure you have everything written out and prepared correctly. We understand that estate planning is not a sexy subject. It's not something everybody wants to talk about. It could sometimes be even complicated, but that's what we're here for. We're here to make sure that you have your peace of mind, your ducks in a row, and it's something that you can leave prepared and not worry about. And knowing that the day that you are no longer here, you have made the right decisions to take that burden off of your loved ones. So if you don't have a will, or you have one done and you haven't looked at it in a very long time, please give us a call. Let us sit down with you and go through your estate planning and try to make it a sexy subject.